We have a panel now of, it's going to be moderated by Adrian Karborani, and this is Forms Update, the all-important Forms Update. And Adrian Karborani is Robert Allen Law. He's an associate there. He works in corporate yacht law and litigation departments at the firm. Adrian is a repeat offender with Eva. Why do we have him back? Because he knows his stuff. You guys can go ahead and sit down. Adrian, take it.
Thank you, Bob, for the introduction. And as Bob said, my name is Adrian Karborani. I'm an attorney at Robert Allen Law. And I'm joined here today by two brilliant closing agents. On the far side, you have Suzanne Hatcher with MarineMax and Julianne Galati with Galati Yacht Sales. And today we're going to be discussing a little bit about the changes to the forms and getting some insight from the closers and how these changes may affect your closings. Okay, so the first topic we're going to cover is dispute resolution, or what happens when your client's pissed off. So the major change we made to the form was the section 17, the back of the form, that you guys probably never take a look at. We moved the primary dispute resolution mechanism from state court in Fort Lauderdale to arbitration. And as you well know, the IYBA has pioneered the creation of the International Yacht Arbitration Council, and the IYAC is now the new dispute resolution body under the contract. And you also have a little bit more flexibility in where you can resolve those disputes. By default, we have choice of Fort Lauderdale, London, or Monaco, and you also have two choice of laws, with that being Florida law or English law. The second option you're going to have under the new dispute resolution clause is, if you're not going to litigate before the IYAC, is to resolve the dispute before the LMAA, the London Maritime Arbitrators Association. And under that section, if you check that box, you'll be resolving the dispute generally in London under English law. And so, question for both of you, have you guys either encountered in litigation directly? How many of your clients do you think have looked at this section of the form, if they look at it at all? Or just, if you haven't dealt with litigation directly, how many clients have you had where they're threatening litigation because something goes wrong and they're pissed off?
Personally, in my short experience, as you can see, I'm pretty young and new into the industry, been around it my whole life. But in my personal experience, I have not come into any contact with disputes and resolutions. In my personal opinion, I'm not sure how many of the customers are, going in depth in reading word for word what it says, and if they know exactly, what they're signing. They get it in front of them, they e-sign it, and that's that. They check that the dollar number's right. Yep, that's what we agreed to. The terms and conditions, that's not the most important to them at the time of signing the contract. So what I think is probably the most important is, as you as brokers, to make sure that you're reading it and that you know what it says. Because at the time, everything's great, happy, they've got their boat deal, they're excited. So if anything were to go wrong, you want to make sure that if anything were to come up and they were to ask you a question, well, now what? You've read the contract and you know what the next steps are.
Great. That's pretty much the summary of the changes. Do you have any questions that you may have? I know I'm putting you on the spot, but do you have any questions you may have thought of just thinking about dispute resolution generally, and how maybe your clients might be interested or that you would want to know?
I think first and foremost, just to kind of simplify things, we can start off with maybe just for everybody in the room, what is arbitration exactly?
Okay, so arbitration is an alternative dispute resolution mechanism. Instead of going into court and resolving the case before a judge, you're going before a private association, and usually, especially but in the case of the IYC especially, you have arbitrators who are acting as judges, but that are specialists in the industry. They know a little bit more than your typical judge will. Well, definitely in this case, they will know than your average judge. The issues that come up with surveys, how the deal actually progresses in the terms of from contract to acceptance to closing. So you're getting a little bit, you're getting specialized knowledge. You're also getting a more efficient process in terms of speed for two reasons. One is specialized knowledge, so you're not there educating a judge on what the issues are that they're trying to resolve or dispute on. You know, you have people that know it. Two is that the process is truncated. So you're not, you know, the discovery process in traditional litigation is, you know, that's what's typically very long and expensive. And in arbitration, the IYSC rules and as well as other bodies, they limit that discovery process, so it becomes a lot more efficient. And then, of course, one of the other benefits, I think, of arbitration is cost. So it's more cost-effective because it's a shorter time period. And then you get a privacy element to it. The court systems are an open, the public policy is that all court documents that are filed are open for public record. And so in arbitration, they're generally sealed. And clients and other individuals won't find out about litigation involving the business, you know, your clients and things like that.
Yeah. So arbitration obviously seems like a great option, but some cases, you know, you have customers who don't agree with the norm. So what happens if a customer or even the brokerage isn't wanting to do arbitration, and that's not what they set out to do?
Right. So if you don't want to do something that's in the contract, the beauty of contract is that you can do whatever you want. The IYBA has just set up a basic mechanism, a default, if you will, to handle disputes that they've, you know, after many much smarter people than I got together and decided it would be the most efficient way to resolve things and would best serve our members, our industry. But you can change, you know, virtually any part of the contract by addendum. But I'd recommend you get a lawyer to do that because you don't want to be hit with an unauthorized practice of law, cease and desist letter, if you will. Not by me, I'd never do that.
So you mentioned the IYAC in the locations that are for their arbitration, Fort Lauderdale, Monaco, London. Is the IYAC flexible at all in the locations, or is it set in stone to those certain locations?
So it's really interesting. I actually asked Mike Karcher, who is the chair of the IYAC, based almost that exact question on another case, and he said, look, if the parties decide that they want to go to Timbuktu to resolve a dispute, then we're going to Timbuktu. So there's a lot of flexibility with that, with IYAC. Yeah.
No, that's great to know. Awesome.
Any other questions?
I think you touched on it a little bit. So why the change? What was the biggest factor into making the change from the previous to now?
Well, definitely to streamline you know, disputes in the event that they do arise. You know, the cost-saving mechanism, adding value to the membership, and the most important thing, in my opinion, is you have experts that really know what they're doing in this industry. And the arbitrators, I put a couple of them up there on the screen, not picking any favorites, it's just the top of the page. They're not just lawyers, they're industry professionals. And you're getting to choose to have somebody to resolve that dispute with tons and tons of industry knowledge. That a judge that you're getting in front of, who knows, you know, has no idea about what's going on. So when it comes to especially technical disputes, the IYC is a huge advantage over traditional litigation.
So when it comes to arbitration and the IYAC and putting it together on the contract, if you were to not check the boxes, you had mentioned that it defaults. What does that default to?
So the default is IYAC arbitration in Fort Lauderdale, Florida, under Florida law. That'll be your default mechanism, which is generally going to be your safest bet. And of course, it's where, you know, a lot of transactions do take place. But as you know, we just discussed, if you want to change that, you don't want to be in Fort Lauderdale, you want to be in Sarasota, just go ahead and prepare a simple addendum and change that provision.
Adrian, is that the only way to change that, is through an addendum, or is there a spot to do that while you're signing?
So on the latest version of the forms, you would have to do it by addendum. But you are going to have the 3 default choices that you can check: London, Fort Lauderdale, or Monaco.
Why don't you take a moment to explain the difference between going to court arbitration, and mediation, because many people don't understand that there's a significant difference between mediation and arbitration.
Okay, yeah, I think we touched basically on the difference between state court and arbitration, but the difference between arbitration and mediation is that mediation is generally non-binding, whereas arbitration is once you have a decision, it's final, it's almost never, it's generally not appealable, very limited circumstances. So when you get a ruling, it's done. Mediation, on the other hand, basically the parties agree to get in front of a neutral third party who helps them try to facilitate or bridge the gap between the dispute. The problem is that mediation, and it's not necessarily a problem, but it's just a caveat, is that it's not binding. So even if you did come to it, even if you did come to somewhat of an agreement, it's not an agreement until it's done, finalized in settlement and writing and signed. And in some cases, it tends to be, if you can't resolve the dispute before you get to arbitration, mediation is not really going to help you. So we're good to change topics here?
I believe so.
All right. Here's a couple more of our colleagues out in Europe. Okay, so the next change that we made was regarding conditional acceptances. And it's a really small change. It's one sentence, but I think it's a really important change, and it's a really great change for you guys as brokers, because what this does is, from a legal perspective, keeps a deal alive. So the change is simply, an acceptance subject to any conditions will be deemed a proposal to amend this PSA and will not preclude the buyer from accepting the vessel unconditionally on or before the accept-reject date. So this change was principally made for two reasons. There's a legal reason, and then there's more of a good faith and fair dealing reason. The legal reason is that submitting a conditional acceptance under the law has the effect of canceling or rejecting the offer that was made originally under the PSA and submitting a counteroffer. So the argument could be made that by submitting a conditional acceptance, you've now terminated the agreement. So if the seller didn't want to accept it, he could walk away and the deal's dead. So in order to keep the deal alive and address this shortcoming, we built into the forms the ability or the language directly saying that it's not going to operate that way. It's only going to be deemed a proposal to amend, and the deal stays alive. If the seller doesn't want to accept anything that's set forth in the conditional acceptance, then the buyer can still choose to accept. And the second reason, as I mentioned, not just legal, it's good faith, it's right. The buyer has spent money going out to the boat at this point by the time they're tendering this conditional acceptance. They've had a survey, they've hauled it out, they've looked at the boat, and now just because they asked for some kind of a concession for a survey deficiency or something that came up, why should they risk the opportunity to still accept the boat if the seller just wants to say no? So those were the two principal primary reasons that the change was made.
So Adrian, with the additional language, how do you talk a buyer through, someone who's not wanting to agree to this additional language? How do you kind of get them to come to the other side with you?
Well, the first thing is, I guess if a seller didn't want to accept the language, I think I would be a little hesitant of why is that a problem? Like if the buyer, you don't have to accept their offer just because they make this proposal to ask for, a $10,000 credit on a sale or something like that, or that you repair, an item on the boat, that you can walk away. It seems like kind of like a little bit of bad faith. Like why is that your approach to this deal? It might be a red flag for you guys, right? Like he's not really looking at the good faith. The other thing is, you can also just educate him a bit, right? Like it doesn't change anything. You made a deal on day one that said, I'm accepting, $1 million for my boat, and if the buyer comes back and says, I want a concession, you say no, it doesn't mean you have to accept it. He's still going to get his $1 million for his boat, or the buyer's going to reject. So I think that's probably the best way to approach it.
And now, on further, can conditions be presented to the seller after?
Absolutely. So just general contract law, even if you have a vessel that's accepted and you have a deal, you can always go back to the table and negotiate something. Closing dates is typically one thing that gets pushed right after acceptance. Vessel wasn't ready, docks aren't ready. They're moving it from one location to another for delivery. So of course, you can always add additional conditions after acceptance.
Adrian, we're going to interject with a question from over this way. There you go, over here.
I just wondered, previously, if we've ever had a conditional acceptance of vessel, we've gone ahead and make an amendment to the contract. Is that still necessary with this added line now, or we just go with conditional acceptance?
No, absolutely. You do need to continue to prepare an addendum. That's the appropriate way to do it. This just, what it does is it operates to prevent the seller from being able to back out of the deal upon presenting the conditional acceptance. Because as I mentioned, it operates legally as a rejection of the original offer, which is the PSA, and a counter offer with new terms.
This change was precipitated by discussion at the board level with the robust market that we've experienced over the last couple of years. You would have backup offers, and let's say Jason has an offer on a 51 Riviera that he has for sale, and James's guy comes and surveys the boat, and the air conditioner's not working. So they go through the whole process. James presents an acceptance of vessel with the condition that Jason's guy fix the air conditioner. Well, Jason's got a backup offer. Not that Jason would ever do this, but Jason's got a backup offer of $20,000 more. The seller's going to say, you know what? I don't want James's deal. I want the one that's $20,000 more. And that's acting in bad faith. Is it something that he could do legally? Yes, but it speaks to, as you mentioned, good faith and fair dealings under the law.
The good faith and fair dealing, and when I use bad faith, I'm not using it in the legal context describing this change, because contractually, legally, right, without the change, they could not accept the proposal to amend, right? And they could just back out of the deal, right? At least the legal argument could be made. So the bad faith that I've mentioned is not like legally bad faith. That's why I said that there's a legal reason and more of like an ethical or good faith reason.
I have a quick question, though. If I present a conditional acceptance and I'm within the date ranges of the contract after survey, and they deny it, they deny that, you're suggesting that they could accept another offer with that presentation during the terms of the contract and the date still in play? No, I understand that, but I still have the opportunity to accept the vessel.
Well,
If you say, no, I'm not going to do that,
Under the old contract, no.
right.
Under the old contract. Let Adrian, you understand what his question is, right? So Adrian will
that's the
explain.
issue that we're addressing here.
Well, I understand that.
Yeah, under the old, yeah.
In the old contract, if that guy's, I'm not fixing the AC. Okay, no problem.
Yeah, so under the old
Okay, no
contract-
problem, I'll accept the boat. You're telling me that he could accept another offer during that timeline of presenting him that?
Legally, it operates as a rejection of the original PSA and a counteroffer. So it's a new offer. The original offer dies, and now you have a new offer.
I understand that. What I'm
So-
saying is you have a right, vote doesn't function, you have a right to try to cure the issues, and you're trying to negotiate it, and you're saying that somebody else could step in with a better offer and take the sale.
Under the old contract? Yeah. Oh,
Well, we had a
ethically-
discussion this morning about the difference between ethics and the law.
yeah. So
And that's-
ethically, yeah, it's wrong.
This room, that if you do that, stuff comes full circle. Just remember.
So that's why you use the new form, and it doesn't happen.
There you go.
But yeah, ethically, it's totally wrong. And the reality is, even though that's the truth, like legally, from a legal perspective, it would operate as a counteroffer and rejection. I mean, how many sellers are going to risk litigation at that point? Like, is it worth it to them to tie up the boat? Like, if they know the buyer's going to accept, it's all a calculation. But we just got rid of that whole dilemma. So that was the purpose behind it. And you don't have to think about it anymore. If a seller's acting that way and they're trying to hold a backup offer, well, this kind of just takes it away, right? It's like we're operating in good faith. I've come here as a buyer, spent money, flown my family out. We've checked out the boat, and now I ask you for something and you're telling me you're going to walk for somebody else, like, that's not right. So this addresses that issue entirely.
Yeah, I agree with the change. I think it's a good change. But just remember, you made a comment about the broker and ethics. It's not the broker's decision. The broker might have presented an offer, and the client may be aware there's a backup offer, and they may be the one that forces the hand, right? It could be the client that pushes that issue. So this is a good change that keeps it alive until the expiration date.
Didn't mean to usurp your question and answer up there, but I think we'll take questions from the audience as they come. Go ahead, you guys.
Absolutely. Suzanne, any other questions on?
I think we covered conditional acceptances.
Beautiful.
If anybody else has
So that was-
anything to add?
Yeah, if anybody else has a question on this is the juicy stuff, as you can tell. So, all right. So the IYBA recently unveiled Spanish language forms, which is definitely the first step in putting the international and the International Yacht Brokers Association, one of the first steps. I guess what I need to tell you guys is that if you are using these forms, what you need to understand and know is that they are prepared in unison. So you're actually going to have the Spanish version form available, and right at the end of it attaches the English version. And the reason we did that was because in order to resolve disputes and disputes with interpretation of the language in the contract, we made the Spanish version governed by the English language version. And so when you have a client signing the Spanish form, it's really a matter of convenience. So you're going to let them be able to read the terms, they're going to understand them. It's professionally translated, so there should be no differences. But if there's a difference in custom or tradition and one person interprets something differently, we're still looking to the English version to resolve that discrepancy. And so when you have a client sign one of these forms, I recommend that they go ahead and fill out both forms, English and Spanish, and then they're going to go ahead and initial and sign each page.
I think, first off, I think this is great. Speaking personally with offices in Costa Rica and Mexico, I can see how this could be a great benefit to our company personally. So I think this is a great step in opening the door, like you said, to the International Yacht Brokers Association, starting with Spanish. I guess jumping into my first question, you had mentioned that both the Spanish and the English version following, and the English taking control if anything were to happen in disputes. So how would you handle a situation if you have a customer, buyer, or seller, whoever it may be, not feeling comfortable with signing a document in a language other than what they speak?
Yeah, that's a tough one, right? Your client's coming to you as the broker, and you're going to have to educate them a little bit and explain to them, like, this is an industry standard form. It was prepared in English, and it's professionally translated into Spanish so that you can read and understand the terms for yourself, and to help facilitate the transaction. But you are still operating essentially under the English language contract. And, obviously, you have to do your job and make your client feel comfortable.
As a matter of convenience, you have it translated into the foreign language. As a matter of law, the English version stands.
Correct. And I just want to mention one other thing. I don't know what version of the PSA that you guys are using or the listing agreement, but if you are going to be using the Spanish forms, please take a look at the revision date at the bottom and make sure that the English and Spanish versions have the exact same revision date. If you download it from your IYBA member portal, they're going to be, as I said, one's appendix to the other. But if you, for some reason, have a copy that's not, you have to ensure that I think it's like 7-point font on the bottom right corner says, revised, 2/1/22, something like that. So just make sure those match exactly.
And Italian and French are coming.
Beautiful. Then that was
You're saying beautiful. They're coming from your office.
I don't speak Italian or French, so they left me out.
But you know a guy.
Okay, so this was just a little bit more of the iteration on the Spanish forms, how we handled the fact that the English version controls. It does say it directly in the Spanish version. So even if you oopsies forgot to tell your client that, by the way, the reason you're signing this English version is because it controls legally over over the Spanish version you're reading. It says it in Spanish to them. So it addresses that issue, and it protects you guys a little bit. And so coming to our last, most riveting topic of the afternoon, we've made some changes to the forms, adding the ability for you to add additional buyers and sellers to the agreements, which I think speaks for itself, but I don't know
Yeah.
if you guys have any comments.
This one definitely comes out self-explanatory. If you have two sellers, you want both of those sellers to sign it. I think that's probably comes off as more important, because if you only have one seller signing, who's to say that the other party isn't just a business partner who had bad terms, or a divorced couple, or something along those lines. So it's extremely important that both sellers are signing, because you want to make sure both are agreeing to the deal.
Yeah, I personally think it's an excellent change. So with that, do we have any other questions?
Not on additional parties, but just mostly of the changes. Are they broker-driven, or how do they find their way to?
Yeah, so that's actually a great question. It's actually from feedback from the membership is how most of these changes are driven. Of course, sometimes the lawyers get involved when they see a legal issue, like on the conditional acceptances, but that change wasn't just driven because of like what the lawyers were saying. It was brokers saying, hey, what about these backup offers that are coming in this market, and they're higher? Like, we want to keep the deal alive. We've already spent all this effort, both the listing and selling broker, and then the buyer going out to see the boat, attend the survey. So it's actually driven by the membership primarily.
So further to that, who decides that you've got 50 brokers saying that this part language needs to change, or you need to add this, and then who's the final deciding?
So Paul, you might want to chime in. Well, the man back there, Bob Allen.
That guy, it's all him.
Actually, there's a forms committee, right? And it has a majority of brokers and a minority of lawyers. So the brokers decide. But there's always a good discussion about it.
Where it usually comes from, Suzanne, is my telephone. People call me and say, this isn't right. Darren calls me and says, do you know what that guy did? He better not ever come around here trying to sell a boat again, because people do things and it gets their feathers ruffled. So we go to the board with these things, or these topics come up through board meetings. And the forms committee consists of Bob Allen, Chris Anderson, Rob Moss, David Moss, John Burkhart, and myself. And when the forms were originally written in 2010, it was Bob and Rob, John and I. And the four of us sat down and authored the new forms based upon what Bob had actually built previously, using the concepts that are tried and tested in the courts from the real estate industry. So we had a great platform. We had the legal minds that knew what the concepts needed to be, and we had the broker minds that wanted to avoid obstacles and not complicate things with too much legalese. And Chris Anderson came into the mix. Chris is a brilliant lawyer, and he was great at putting it all down and collating it and putting it together. And then David Moss has come aboard there because, just to tag on to the forms discussion, what IYBA now also has is a bareboat charter agreement, a vessel services agreement, a captain's guide, and a charterer certification, as well as a term charter agreement and a vessel services agreement that dovetails with those. So what we do is we get input from the membership, we get input from board meetings, and we go to the forms committee with these concepts. And sometimes people come to me and say, this isn't right, and I'll call Bob and say, what's the deal with this? And he says, it's totally in violation of the Uniform Code of Conduct. You can't do that. This is why it's written, and I can call them back and they can understand it. But that's how forms changes are precipitated.
All right, so we'll open it to the floor if there's any other.
Are there any other questions that we have? Coffee, cookies? Bob, do you want to take them to break? Sure do. Oh, wait a second. Joe Dargavich has a question.
Suzanne, where is it that MarineMax Naples goes on their rendezvous again?
That would be Remora Bay.
Yeah, thank you.
Shameless plugs.
Well, thank you, guys. And thank you.
Thank you.
Thank you. This was awesome.
All right, no announcements. You deserve a break. Go on out there, grab some coffee, some caffeine. There's some goodies out there as well. We'll see you in back about 15, maybe 10. We'll see. Listen for the call.